Big immigration change today in USA. Green card holders need this update. Today marks a significant and historic moment in United States immigration policy. A major immigration change has officially taken effect, and its impact will be felt immediately across millions of lives. If you are a green card holder, a future applicant, or someone whose family depends on the U.S. immigration system, this update is not optional knowledge. It is essential. This is not speculation, rumor, or political commentary. This law has already passed, and its provisions are now actively shaping how immigration decisions are made. For many, this change represents long-awaited progress. For others, it introduces stricter rules that require attention, planning, and compliance. Immigration is no longer operating under the same assumptions as before, and failing to understand these changes could lead to serious consequences. This update affects how quickly applications are processed, how permanent resident status is maintained, how long residents may stay outside the country, and how financial stability is evaluated. It also introduces entirely new pathways for specific groups while tightening oversight in other areas. If you have ever wondered whether immigration policy can truly change lives overnight, today provides that answer. This law reshapes the immigration landscape in ways that will influence decisions for years to come. Whether you are already a lawful permanent resident or still navigating the long road toward one, understanding these changes is now part of protecting your future. A shift from delays to deadlines. One of the most transformative aspects of this new immigration law is the shift from open-ended delays to enforceable processing timelines. For decades, the U.S. immigration system has been criticized for inefficiency, backlogs, and lack of accountability. Applicants were often left waiting for years with little clarity about when decisions would be made. This uncertainty affected careers, families, mental health, and long-term planning. Under the new law, employment-based green card applications are now subject to a mandatory processing window. Immigration authorities are required to adjudicate most cases within 180 days. This is not a recommendation or internal guideline. It is now a legal requirement. For skilled professionals who have waited years due to country-based caps and administrative backlogs, this marks a fundamental change in how the system operates. To make this possible, the federal government has authorized increased funding for immigration operations. This includes hiring additional adjudication officers, expanding training programs, upgrading case management systems, and modernizing digital infrastructure that has not kept pace with demand. The goal is not merely faster decisions, but more consistent and transparent outcomes. For applicants currently on temporary work visas such as H-1B, L-1, or O-1, this change could significantly reduce uncertainty. Priority dates that once seemed frozen may finally begin to move. Families that delayed major life decisions due to immigration uncertainty may now have clearer timelines. This shift signals that backlog reduction is no longer optional. It is now a legal obligation. Premium processing expansion and its implications. Another major development under the new law is the expansion of premium processing. Historically, premium processing was limited to certain temporary visa categories, allowing applicants to pay an additional fee for faster decisions. Green card applicants were largely excluded from this option, regardless of urgency or personal circumstances. That is now changing. For the first time, certain green card applicants will be eligible to request expedited processing by paying an additional fee. While exact eligibility criteria are still being finalized, early guidance indicates that decisions could be issued within 30 to 45 days for qualifying cases. This does not guarantee approval, but it guarantees a timely decision. This expansion introduces both opportunity and responsibility. While faster processing can be life-changing, applicants must ensure their submissions are complete, accurate, and well-documented. Errors, omissions, or inconsistencies may still result in delays or denials, regardless of processing speed. Legal guidance and careful preparation are more important than ever. The broader message from lawmakers is clear. The era of indefinite waiting is coming to an end. Immigration benefits are being reframed as processes with timelines, accountability, and consequences for delay. Stricter expectations for green card holders. While many changes under this law offer relief, others introduce stricter expectations, particularly for existing green card holders. Lawful permanent residence has always carried responsibilities, but enforcement of those responsibilities is now becoming more consistent and data-driven. One of the most important changes involves time spent outside the United States. For years, many green card holders believed that returning to the U.S. once per year was sufficient to maintain status. Under the new framework, that assumption is no longer reliable. Spending more than 6 months outside the country without a re-entry permit may now trigger additional scrutiny during re-entry or future applications. Absences exceeding 1 year present even greater risk. Unless a green card holder can clearly demonstrate strong and continuous ties to the United States, extended absences may be interpreted as abandonment of permanent residence. Immigration officers will now place greater emphasis on objective indicators such as employment history, family presence, property ownership, tax filings, and overall integration into U.S. life. The intention behind this change is not to punish legitimate residents, but to reinforce the definition of permanent residency. Green cards are intended for individuals who live, work, and build their lives in the United States, not as long-term travel documents or backup options. Annual residence confirmation requirement. In addition to travel-related scrutiny, the law introduces a new annual residence confirmation requirement for all green card holders. Each year, permanent residents must complete a brief online confirmation verifying their U.S. address and continued residence. The process is designed to be simple and accessible, typically requiring only a few minutes. However, the consequences of non-compliance can be serious. Failure to submit this confirmation may result in delays during future applications, requests for additional evidence, or complications during travel. In some cases, repeated non-compliance could raise questions about intent to maintain permanent residence. This requirement reflects a broader trend toward digital oversight and proactive compliance. Immigration status is no longer something that can be ignored between renewals. Staying organized, meeting deadlines, and maintaining accurate records are now essential components of protecting lawful status. Healthcare workers, a priority pathway. Among the most impactful provisions of the new law is the creation of a fast-track green card pathway for healthcare professionals. The United States is facing a severe shortage of healthcare workers, affecting hospitals, clinics, long-term care facilities, and home health services nationwide. This law directly addresses that reality. Eligible healthcare workers, including nurses, physicians, therapists, medical technicians, and home care professionals, may now apply for permanent residence through a streamlined process. In many cases, the traditional labor certification requirement, which often causes years of delay, may be waived or expedited. An additional 25,000 green cards per year have been allocated exclusively for healthcare workers, separate from existing numerical caps. This significantly reduces competition and accelerates approval timelines for qualified applicants. For healthcare professionals already working in the U.S. on temporary visas, this change offers both opportunity and stability. The law also strengthens worker protections within the healthcare sector. Employers are prohibited from using visa dependency as leverage for underpayment or unfair working conditions. Fair wages and lawful treatment are now directly tied to immigration eligibility, creating stronger safeguards for workers and reinforcing ethical employment practices. Financial self-sufficiency and public charge review. While the law expands opportunities in many areas, it also reinforces financial scrutiny through strengthened public charge considerations. Immigration officers are now required to more closely evaluate whether applicants are financially self-sufficient and unlikely to rely on long-term public assistance. Extended use of certain public benefits, particularly for more than 12 months within a 3-year period, may negatively affect applications or renewals. However, the law emphasizes context. Short-term assistance due to emergencies such as medical crises, job loss, or family hardship will not automatically disqualify an applicant. What matters most is the overall financial picture. Officers will consider employment history, income stability, savings, education, and long-term prospects. Applicants are encouraged to demonstrate proactive financial planning, even if their resources are modest. The goal is sustainability, not wealth. This provision underscores the importance of preparation. Individuals planning to apply for permanent residence should begin organizing financial records early, seek employment where possible, and consult with qualified professionals to understand how their financial history may be evaluated. A permanent pathway for those brought as children. One of the most emotional and historic elements of the new law addresses individuals who were brought to the United States as children and grew up in American communities. For the first time, a permanent and statutory pathway to lawful permanent residence has been established for these individuals. Eligible applicants who meet requirements related to education, employment, community contribution, and background checks may now apply directly for green cards. This removes the uncertainty associated with temporary protections and repeated renewals. Applications in this category will be prioritized, with a target processing time of approximately 12 months. The law also allows eligible individuals to sponsor immediate family members, helping reunite families that have lived with uncertainty for decades. Financial assistance for application fees is included, acknowledging the economic barriers many have faced due to their status. For countless families, this provision represents stability, recognition, and the opportunity to plan for the future without fear. Entrepreneurs, startups, and job creators. The law introduces major changes for entrepreneurs and investors, recognizing the role of innovation and job creation in the U.S. economy. A new startup-focused immigration pathway allows founders to apply for permanent residence if their businesses demonstrate measurable economic impact. Requirements include raising a minimum amount of qualifying investment, creating a specified number of full-time jobs for U.S. workers, and maintaining active involvement in business operations. This pathway addresses a long-standing gap where successful founders were forced to leave the country due to lack of sponsorship options. Investment thresholds under existing investor programs have also been adjusted in certain regions to improve accessibility while maintaining strong fraud protections. Only legitimate businesses and verifiable investments qualify, ensuring integrity within the system. For innovators and entrepreneurs, this law represents a long-awaited invitation to build, grow, and remain in the United States without constant immigration uncertainty. Biometric renewals and digital green cards. Another change that will affect every green card holder is the introduction of mandatory biometric renewals every 10 years. Beginning 6 months from now, permanent residents must update fingerprints, photographs, and identity verification through a streamlined process. Alongside this requirement, a secure digital green card will be introduced. In addition to the physical card, residents will have access to a protected digital version that can be used for employment verification, travel, and identification. This system is designed to increase security, reduce fraud, and simplify everyday interactions. While the biometric process itself is brief, participation is mandatory. Failure to comply could result in delays or complications. As with other changes under this law, staying informed and proactive is essential. What this means moving forward. Change in immigration law often brings uncertainty, but it also brings opportunity. This law represents a shift toward modernization, accountability, and long-term stability. It rewards compliance, preparation, and genuine commitment to life in the United States while tightening oversight where necessary. For green card holders, this is a moment to reassess travel habits, documentation, and long-term plans. For applicants, it is a reminder that preparation, accuracy, and awareness are more important than ever. Immigration is no longer static. It is evolving, and those who adapt early will be best positioned to succeed. If you are watching this today, take a moment to reflect on where you stand in your immigration journey. Whether you are already a permanent resident or still working toward that goal, this law shapes the road ahead. Staying informed today can protect your future tomorrow.